Let's dive right into this explainer. Today, we're looking at a genuinely fascinating constitutional clash from 1999 over voter ID requirements in South Africa. This was a landmark case brought by the Democratic Party against the Minister of Home Affairs, and it essentially stress-tested the mechanics of a very young democracy. We're talking about a country preparing for only its second massive national election since the end of apartheid. Ultimately, it's a story about the fundamental right to vote, the absolute logistical nightmare of running an election, and a huge legal question: who actually bears the burden of proof when you want to challenge a law?
Here's how we're going to break this down today. First, the historical context. Then, challenging the act, the equality argument, the push for evidence, and we'll wrap up with the final verdict.
All right, Section 1, Historical Context and the Race to the Polls.
To really get why this case was so intense, you have to think about the timeline. It brilliantly illustrates the absolute urgency of the situation. The Constitutional Court held the hearing on March 29, 1999, and they turned around and delivered their decision by April 13th. Why the massive rush? Because the general national election was happening just weeks later, on June 2nd. The entire legal machinery of the country was operating under this impossibly tight deadline. And get this, it was actually the second time a political party had attacked the Electoral Act of 1998, right on the heels of a similar case by the New National Party. So yeah, the stakes could not have been higher.
Moving on to Section 2, Challenging the Electoral Act, the core conflict.
Imagine for a second finding out that the ID you have used for years is suddenly completely invalid for voting. That's what sparked this. The Democratic Party mounted a direct challenge to the Electoral Act of 1998 because the act mandated that voters had to possess a very specific document to register and vote: the newer, green, barcoded identity document. The DP argued there was absolutely no rational reason why older identity documents, the ones issued before 1986, shouldn't be accepted right alongside the new green ones.
The bedrock of the DP's argument was basically this: these new barcoded IDs offered zero practical advantage over the older IDs when it came to just registering and voting. And because of that, they argued there was no rational connection between forcing people to get the new ID and any legitimate government purpose. In their eyes, by forcing citizens to jump through this hoop, the Electoral Act was unreasonably infringing on a citizen's constitutional right to vote, which is protected under Section 19(3)(a) of the Constitution.
Which brings us to Section 3, the equality argument, data and demographics.
To really drive their case home, the DP leaned heavily on a legal concept called indirect discrimination. Now, direct discrimination is easy to spot, right? It's a law that explicitly targets a specific group. But indirect discrimination, that's when a law looks totally neutral on paper, like simply saying, hey, everyone needs a green ID. But in actual practice, it disproportionately and negatively impacts specific vulnerable groups. The DP argued the Electoral Act did exactly this. They said it unfairly penalized rural, young, or white voters who, just statistically, were less likely to have the new IDs.
The DP backed this up with polling data from the Human Sciences Research Council, specifically the Opinion 99 polls. The contrast here is actually pretty stark. The data showed that 82% of likely ANC voters and 84% of likely IFP voters already had the correct IDs. But when you look at the likely Democratic Party voters, only 65% of them had the required green barcoded documents.
So this set up a massive, defining constitutional question for the court. Did this polling data actually prove that the new ID mandate unfairly discriminated against the DP's voter base? Because if it did, the law could be thrown out as unconstitutional. The DP's whole point was that this statistical difference across party lines was concrete evidence of unfair discrimination.
Well, Justice Goldstone, who delivered the judgment for the majority, systematically dismantled that argument. First off, he pointed out a pretty huge flaw in the timeline. Those polls, they were taken between August and October of 1998. That was way before any of the national voter registration drives even kicked off. Secondly, and this is the real legal kicker, the DP failed to prove causation. Just because there's a disparity doesn't mean the Electoral Act caused it. Justice Goldstone noted there were plenty of other factors that could explain why different demographics had different IDs. Plus, political parties had almost certainly been running massive voter education drives since the polls were taken to get their voters the right documents. Basically, without hard proof that the law itself caused the unequal impact, the equality argument completely fell apart.
Let's pivot to Section 4, the push for oral evidence regarding department capacity.
During all of this, the DP tried to hit the brakes. They asked the court to pause and let them introduce oral evidence. Why? Because they wanted to prove that the Department of Home Affairs literally did not have the physical or administrative capacity to print and deliver all these required barcoded IDs before voter registration closed in March. They were essentially arguing that the department's own data on ID production just didn't add up.
But the Constitutional Court firmly said no, and this highlights a really important distinction in constitutional law. Failures in implementation don't automatically make the underlying law unconstitutional. The court pointed out that the DP was legally challenging the constitutionality of the Electoral Act's provisions, not the department's operational failures. The DP hadn't actually formally sought relief regarding the implementation of the law. And on top of all that, remember the timeline? The extreme urgency of the looming election meant that going down a rabbit hole of oral evidence about printing capacities would have totally derailed the schedule. So the court ruled that refusing this new evidence was absolutely the right call.
And that brings us to Section 5, the court's final verdict, and the burden of proof.
So how did it all end? The Constitutional Court dismissed the appeal. Justice Goldstone concluded that the burden of proof, or the onus in legal speak, was entirely on the Democratic Party to prove the Electoral Act was unconstitutional right when it was promulgated. Because the DP couldn't definitively prove that the ID requirement was an unreasonable limitation of rights, or that it actually caused unfair discrimination, they failed to meet that burden. The appeal was thrown out, though interestingly, the court didn't order the DP to pay costs, which was a subtle acknowledgement that the government had passed the act pretty late in the game.
Now, to really grasp the full picture here, it's crucial to mention that this decision wasn't unanimous. Justice O'Regan actually issued a formal dissenting opinion. She firmly disagreed with the majority on how the limitation of constitutional rights should be interpreted in this specific context. She echoed the same detailed reasons she gave in her dissent for the parallel New National Party case, which was decided on the exact same day. It just goes to show that even at the highest levels of the judiciary, the exact line between securing an election and limiting a democratic right is fiercely debated.
To wrap up this explainer, I want to leave you with a thought that goes way beyond 1999. The core tension in this case is something literally every modern democracy has to grapple with. How do we perfectly balance the need for strict, secure elections, knowing for sure that everyone who votes is exactly who they say they are, with the absolute necessity of ensuring every single citizen has fair and equal access to the ballot box? The green barcoded ID might have been the flashpoint here, but that underlying principle, that is timeless. Thanks so much for joining me on this deep dive.